So the Supreme Court will now consider whether the federal law which prohibits nonviolent felons from possessing firearms is in fact a violation of the Second Amendment. So let's talk about this. But real quick before we jump into this video, if you think restricting the people from being able to keep and bear arms is unconstitutional, go ahead and hit that like button and subscribe. Also, I want to mention that we have channel merch available. You can get this shirt and then also the Text, History, and Tradition shirt, which is a play on the Bruen decision. We also have a channel patch, and then also on TriStar Trading Co., you can find other influencer merch and then things like the Whoopie, which I have coming and I'm really excited for. So again, check out TriStar Trading Co., check out the channel merch, and I will leave a link down below where you can find it. As I mentioned in the intro, in this video, we're going to be discussing a huge Second Amendment case that has now been submitted to the Supreme Court for consideration and is asking for Supreme Court review. The case we're going to be talking about in this video is called Range v. Garland, and it involves a challenge to the federal laws which prohibit someone who is a nonviolent felon, or someone who has a felony, a nonviolent felony, or a misdemeanor equivalent from being able to own, possess, or acquire firearms. The federal government has now asked the Supreme Court to take review of this case since they recently lost a decision in the Third Circuit before an en banc panel. Now, this case originally found its way to the Third Circuit en banc panel because 26 years ago, the individual here, the plaintiff, Brian Range, was convicted of concealing some of his income so that he could obtain food stamps in the state of Pennsylvania. Essentially, he wanted food stamps for his family, so he made a false statement on one of the forms on some paperwork about how much income he actually had. Because of that, he was charged and convicted of a Class 1 misdemeanor within the state. Mr. Range had no other serious criminal issues, no other convictions, and simply it was just him concealing some income on that food stamp form. However, because of that one ancient misdemeanor conviction, the government bans Mr. Range from being forever from possessing or purchasing firearms. Mr. Range brought this lawsuit originally before a district court in Pennsylvania against the Attorney General and also the ATF, seeking declaratory and injunctive relief. He sought for the federal government to no longer be able to bar him from purchasing, possessing, or owning firearms because of that one nonviolent misdemeanor. However, the district court ruled in favor of the government on a motion for summary judgment. In reaching their decision, the court used something known as the two-step approach. However, after that decision, the Supreme Court issued their New York State Rifle and Pistol Association case, which found that the use of the two-step approach is inappropriate when you look at Second Amendment cases. Now, after losing at the district court level, Mr. Range appealed up to the Third Circuit. On review, a 3-judge panel in the Third Circuit issued an opinion upholding the lower court's decision, and they used the Bruen opinion. The 3-judge panel cited history and tradition in finding that individuals constitutionally entitled to bear arms are only law-abiding, responsible citizens. So there, the Third Circuit 3-judge panel found that his misdemeanor, although non-violent, qualified under 922G1 and therefore excluded him from the class of the people afforded the right to keep and bear arms. Well, Mr. Range did not quit, and he sought en banc panel review of that decision. And on review, the Third Circuit en banc panel found that Section 922G1 as applied to Mr. Range is in fact unconstitutional. In their decision, the majority discussed how their precedent that they had used prior was incorrect because they used the two-step approach, which again was expressly rejected by Bruen. They also went on to say that Range's appeal instead requires us to examine who is among the people protected by the Second Amendment. Range claims he is one of the people entitled to keep and bear arms, and that our nation has no historical tradition of disarming people like him. The government responds that Range has not been one of the people since 1995, when he pled guilty in Pennsylvania State Court to making a false statement on his food stamp application, and that his disarmament is historically supported. So here the Third Circuit is nicely clarifying what is the whole issue in this case. The government claims that Mr. Range is not part of the people mentioned in the text of the Second Amendment, the right of the people to keep and bear arms. The government claims that the nonviolent food stamp conviction makes him fall outside the class of people protected by the Second Amendment. The court stated in their decision that in sum, we reject the government's contention that only law-abiding, responsible citizens are counted among the people protected by the Second Amendment. Heller and its progeny led us to conclude that Brian Range remains among the people despite his 1995 false statement conviction. Having determined that Mr. Range is one of the people, we turn to the easy question: whether Section 922G1 regulates Second Amendment conduct. It does. Range's request to possess a rifle to hunt and a shotgun to defend himself at home tracks the constitutional right as defined by Heller. So, the Second Amendment's plain text covers Range's conduct, and the Constitution presumptively protects that conduct. They then moved on to determine if the government showed that there's any historical evidence to support stripping Mr. Range of his right to keep and bear arms forever. On that issue, the court concluded there is no evidence. And based on that, the Third Circuit reversed the lower court's decision and ordered that they issue a declaratory judgment in favor of Mr. Range. That judgment prevents the government from enforcing 922G1 against him specifically. Now, in response to that decision, the government was put in a really hard position. Their only option was to seek Supreme Court review, but the Supreme Court recently granted review in a different case called the Rahimi case, which deals with the federal law which prohibits individuals subject to domestic violence restraining orders from purchasing or possessing firearms, a similar issue but a different section of the federal law. The risk with seeking Supreme Court review in this Range case is that the Rahimi case is a little bit better than the government, so the government maybe is fearing that the Range case would influence Rahimi if they were taken together. Now, in the brief, the government states that the en banc panel, Third Circuit, held a long-standing federal statute unconstitutional as applied to Range, and opened the courthouse doors to an untold number of future challenges by other felons based on their own particular offenses, histories, and personal circumstances. The Court of Appeals decision contradicts the historical understanding of the right to keep and bear arms, as well as this court's assurances that the Second Amendment does not cast doubt on felon disarmament laws. They go on to argue that this court should not leave the decision below in place, but because the court is already considering closely related Second Amendment issues in U.S. v. Rahimi, plenary review is not warranted at this time. The court should instead hold the petition for a writ of certiorari pending its decision in Rahimi, and then dispose of the petition as appropriate. So the government is filing a writ of cert to the Supreme Court, but they're not really asking for review in this case. Instead, they ask the court to hold this case until they decide the Rahimi case. That is because the government believes that Rahimi in that case and the facts involved in that case are more likely going to result in a positive outcome for them, the government. If the Supreme Court takes this case and the facts along with Rahimi, there is a strong possibility that the government will lose this case, and maybe this case would also impact what the Supreme Court says in the Rahimi case. Instead, the government likes the facts in Rahimi more, so they want to isolate review of this whole question of who are the people in the Second Amendment to just the facts in Rahimi. They don't want this Range case kind of mudding that case because they believe they have the best opportunity to win in Rahimi. They hope a positive outcome in Rahimi can then be used by them to go back to the Third Circuit and have the Third Circuit have to overrule what they said already in the Range case. In their petition, the government states that this court should hold this petition for Rahimi. After deciding Rahimi, the court should 1. Grant this petition, vacate the Court of Appeals judgment, and remand the case for reconsideration in light of Rahimi. Or 2. Grant plenary review in this case or in another case that provides a more suitable vehicle for resolving Section 922G1's constitutionality. So this is definitely an interesting situation. I personally believe that the Range case is better than Rahimi case. I was hoping that the Range case would make it first to the Supreme Court and that maybe the Supreme Court would not grant review in Rahimi, but they've already granted review, and I believe arguments or oral arguments are set for November 7th, so they are moving on the Rahimi case. We will get a decision before the end of their next term. I hope the Supreme Court does decide to take up the Range case and not just hold it. I think that decision here in Range will also prevent a negative outcome in the Rahimi case, but of course the government wants the Supreme Court to hold this case here Range and only decide on Rahimi, and so they want that because they know that the Range case is probably worse for them. Now, additional briefs will need to be submitted in the Range case, and then we will ultimately see what the Supreme Court decides to do. But if we get any more information or any more developments, of course, I will let you guys know. If you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.